Well, everyone, thank you for joining us tonight. We are excited to have you and to talk about sometimes the steps that are needed when an estate plan is incomplete or maybe doesn't exist at all. And so I know we know a lot of familiar faces on here, but to get started, we'll just introduce ourselves and our businesses and then dive into some of the content. So today we're going to talk about the legal considerations of an incomplete estate plan. Brandon and Alex will touch on that side of things. And then I'm going to talk a little bit more about the non-legal aspects that come up. I know some of us are familiar with that, but some of the things that more commonly pop up for folks. And then we'll close and talk about some solutions that exist and also just any questions and answers. I think we have a small enough group tonight. If there's questions along the way, feel free to pop them in the chat, and we'll moderate that or just unmute and ask. I think that we have a small enough group that we can probably accommodate that. So to start, for those of you, we know everyone here, but Kylee with After Loss Advisors, we provide concierge services to folks in two areas of need. The first is with legacy and estate organizing, so helping people while they are still cognitively able and alive to navigate all of the components of their estate that needs organizing outside of the legal and financial realm. So we work with partners like Brandon and Alex to help folks get their estate plans, trusts, things like that put in place. And we also work with them to make sure things like directories of personal property, directories of important items, digital password management, and all of the non-legal and financial things are organized. So that way they can have that peace of mind. And then after a loss, we support folks with the empathetic detective work that's often needed to navigate an estate. And again, in conjunction with professionals like some of the folks here on the call today and Brandon and Alex. So I'll pass it to them to introduce themselves.
So my name is Brandon Campbell. There's only one of you I think that I don't know on this call. And then this is Alex Greene. She'll pop up whenever she starts talking. So our law firm, we are located in Parker. We do serve all of Colorado, but we're located in downtown Parker. We have two major sides to our practice. This particular side, we handle a pretty large amount of estate planning and what we call administration, which is helping people actually carry out things, whether they have an estate plan, they don't have an estate plan, if they have a trust, whatever the circumstances. So we cross a few different thresholds. We do a lot in the estate realm, which is going to be your main assets and such. We also do a lot of business work and we do a lot of real estate work. So our firm can transcend kind of a large spectrum just so that people don't have to end up having multiple attorneys to deal with all of the kind of same issues, related issues. So we have ourselves, we have more attorneys coming on, which is great. And then we have a wonderful staff of paralegals who kind of help us push all of these matters forward.
Great. So we
And
will
then,
pass it. Oh, sorry, Alex. How dare I? Go ahead.
oh, you're totally fine. I'm Alex Greene. I'm an associate attorney with Brandon, and I help him with estate planning stuff, and then I handle most of the probate matters in our office. Yeah, that's all.
Great. All right. So we will pass it to Brandon and Alex to get started with the legal considerations of an incomplete estate plan.
So the first thing, just to give everybody a little bit of a refresher, we call this an estate plan because when you end up in probate, when we pass away, it's called an estate. So when we talk about how we're going to be preparing for that, that is estate planning. That's actually where that term comes from. So an actual estate plan that is created is something that's designed to avoid going to probate, to not have my family, my friends, my whoever deal with the court system, deal with all of the frustrations, the costs, and the complications of that. If you have an estate plan, or if your loved one or whoever is at issue here has an estate plan, there are a few components that are usually going to be involved. The first will be powers of attorney. These are legal documents that we create while we're alive that essentially say, I'm going to manage my own decisions and take care of my own life. But if I reach a point that I'm not able to do that, what we legally call incapacity, then I'm going to install people through these documents to make those decisions and continue taking care of my life for the rest of it. These are usually divided into two categories. One is going to handle medical, including working with doctors, making decisions, managing health insurance claims. And the other is going to be what you can just really simply call financial, what's commonly referred to as a general power of attorney, covering everything non-medical. This is from making sure my bills are getting paid, filing my tax returns each year, managing my house, my car, my investments, and so on. Powers of attorney are designed to allow us to avoid probate because we're identifying the next people who will step into our shoes. Medical directives are documents that are usually in an estate plan. They include a living will and also commonly a document we might just call a HIPAA authorization. These exist not really to deal with probate issues. They're more designed to make people's lives easier. They make some decisions in advance. They also provide key access to being able to do things like talk to doctors. Wills are documents that are a part of every person's estate plan, regardless of your structuring, your intentions, your family makeup, your wealth. But one of the common misconceptions is wills do not avoid probate. That's not their purpose. It's true across all 50 states. It's never been the purpose of a will. In order to use a will, you must take it through probate. So when we do estate planning, we take steps necessary to not go through probate, which by its nature then means that we don't have to use wills. Wills are documents that essentially act as backup plans. They are the safety net. They are a probate instruction manual that if we do have to go through that process, it identifies all of the steps, all of the people, all of the layout really of the plan so that it's carried out in the way that we want. They do make probate easier and faster and cheaper, but in planning, our objective typically is don't go through probate because you can achieve that. What you will commonly find though is most people that you encounter who have an estate plan, they have a will of some kind. Maybe they've gone through an attorney, maybe they've just downloaded a form, whatever the situation. One of the pieces we usually have to kind of dispel for people is a will is not an estate plan. The will is typically the least valuable document that we have, but it's at least something to make sure that things happen the way that we want them to when we're gone. And then a lot of estate plans are going to involve the use of trusts. There's different types of trusts. There are different ways to go about creating trusts, whether one person creates it on their own or spouses create them together. But the very simple concept of a trust is it's an entity that we create while we're alive to take ownership of all of our assets. And then after we're gone, that entity continues. It owns the inheritance, it manages it, and it provides a plan for who gets to inherit it and when they get to inherit it and how it gets used, how it's managed. They allow us to create special rules and contingencies, such as protecting assets from our children's spouses, or dealing with issues of drug and alcohol problems, or planning for what happens when our heirs pass away, where the inheritance goes next. So we're going to talk a little bit more on the Thursday segment about how to actually implement an estate plan. But for today's purposes, the crux of this is really we find ourselves in a couple of key situations. One is there might be people that we have, whether friends or family, that we're helping, even ourselves potentially, where there isn't a plan or there's an incomplete plan. A common example, like I just said, is most people think that they just need a will. Well, that doesn't work because if I have an accident and I'm in the hospital somewhere, somebody needs to be able to talk to my doctors and make decisions for me. Well, a will doesn't allow you to do that. So what do we do in response to that? Or we might have people who have an estate plan, but they haven't done anything necessary to implement it, which is the next topic. And so we find ourselves then when we pass away having to process everything through probate and really kind of defeating the purpose of having a plan in the first place. So for today, what we're going to be covering is really the plan is designed to not go through probate. Well, what happens when we have to go through probate? And so I'm going to have you go to the next slide, Kylie. Alex is going to cover probate for us.
All right. So Brandon's mentioned it a little bit, but if we don't have documents in place and we become what he mentioned as incapacitated, can be temporary, you're in a car accident, something like that, or permanently, frequently when we get older, or have a traumatic injury, brain injury, something like that, we can become permanently incapacitated. And without any proper planning, nobody can just step into our shoes and make decisions. Not a spouse, child, family member, nobody. So you end up in cases called guardianship and conservatorship. Guardianship covers medical decisions. Conservatorship covers financial decisions, just like you have a medical power of attorney and one for everything else, all your financials. We have two different types of cases. They get filed into the same case, but it's two sets of paperwork. It's two sets of reports that you have to file every year if you're named a guardian or conservator of somebody. They require you to file something with the court, a report with the court every year saying, you know, here's what's happened to this person in the last year. It's just miserable. It's time consuming. Emergency appointments, like when you're working with an attorney like me, is even more expensive because I have to do emergency and then permanent 2 months later. It's a whole process that is just so easy to avoid with proper planning, which is why we advocate for it so heavily. Because in those emergency situations, you don't want to have to wait a week, even in an emergency. Haven't gotten an emergency appointment in less than a week. It's usually takes about 7 days to get that appointment. And then that's while we're alive. So that's kind of what we call probate round one kind of situation. And then Kylie, if you can move
And
to.
I'm actually going to interject two
Go ahead.
quick notes. One is if we end up in a guardian and conservator situation, that's it. We're there. So when we're in a, for example, a permanent situation of incapacity, I've got dementia or something like that. This isn't just somebody steps in and they get appointed and now they get to take the reins and go. That conservator and guardianship lasts the entire rest of my lifetime. And so not only are we under the court's thumb for all of that, and we might have restrictions, like I might not even be able to pay a bill without asking permission from the judge. But the other big thing is cost. If we're in a court case and there are costs associated with that every single year, and we're in that for 10 or 20 years, that really racks up on top of the extraordinary costs we're already paying. The other thing I just wanted to note is all of you here likely have family and friends that are in other states. One of the little technical frustrations is number one, these things don't carry over. So if I'm a guardian and conservator for a sibling here, and then we relocate them to another state or something like that, we don't have to go through the whole process of opening a new case in that other state and moving everything over to it, versus a power of attorney just crosses state lines. They also go by a bunch of different names. So any of you in the industry, we have conservator in Colorado. I'm from Illinois. They don't do conservatorships there. We have guardian of the estate, which is financial, and guardian of the person, which is medical. So even like terminology can be drastically different from state to state. So it's really hard to keep up with this for a lot of people. And you might not always be able to do what you think you do because you're a guardian in one state, but that doesn't mean the same thing in the other states. So it's just mind numbing. So anyway,
Yeah,
don't go through this.
no. As guardian and conservator, you're also liable for what's happening to that person. You, like Brandon said, you can't move them out of state. Not only do you have to move the case to a different state, but you have to ask permission from this state to move them to another state, if you're guardian of them. So there's just a lot of restrictions on it that can be really hindering to people. We won't even get into the mental health side of guardianship and conservatorship and all of that. If somebody has a mental health issue instead of more of what they consider medical. But so that's while we're alive. When we pass away, our whole estate sometimes has to go through probate if we don't have any estate plan, or sometimes things just slip through the cracks. Some people buy a new house and don't put it in their estate plan properly, and we end up having to go through probate anyway, even if you have documents. So the whole reason that we go through probate, it's done, just so you know, in the county where the person lived, or lives if it's guardianship and conservatorship. And the whole reason we go through it is because of how assets are titled. So if there's no planning in place, when the owner of an asset, say a house, if passes away, or when both owners of a house have passed away, that family has no legal right to sell that house, to rent it out, to move it into their own names. Whatever the situation is, they have to go through probate. So it's a whole court process. The family member goes into the court, says, okay, my mom has now passed away. This house is in her name. It's stuck there. The judge says, okay, you are now her personal representative, or the personal representative of the estate. These used to be called executors. Now we call them personal representatives. Same thing. It basically means the personal representative becomes the person that passed away. They can access bank accounts, they can sell property, whatever they need to do, they can do, usually. Judges can put restrictions on it, but for the most part, they can do anything. But again, it's a lot of court oversight. There's a lot of paperwork that goes into it. Sometimes there's hearings that you have to go to get appointed. And then dealing with all of the family, we create a very large settlement agreement between everybody to make sure that, hey, everybody gets the right document or gets the right assets. They're satisfied with what they got. They're not going to come back against the personal representative, which is always a mess. There's a whole creditor period where creditors can come. Legally, they have a year. We can shorten it to 4 months by filing notice to creditors, but creditors can come and try and take from the estate if there's, outstanding debts, all done through the probate court. And it takes, in Colorado, I would say, if everybody's on top of everything, it takes us at the very least 6 months, frequently closer to a year, 10 to 12 months to get through probate. It can take a lot longer. We've got cases that are still open from like 2017 because people never finished, and even farther back. And the longer you wait to do it, the more complicated it becomes, because some families are like, I don't want to deal with this right now. It's too hard, too complicated. And the more years that pass, it actually can become somewhat harder to figure out just the line of succession, the line, like who actually is involved here. Sometimes the court looks at me funny when I bring in a will for somebody that's passed away in 2007. I'm like, why are we here now? So it's really just a miserable process. And again, like Brandon said, a will doesn't avoid this. It just makes it faster and easier and cheaper if I can.
When that will actually works. There's a case that we're just starting as of today where the will was signed in 1974. And if you can imagine, a couple of things have changed. So we have situations now where in this case there was a will, but everybody in it is dead. And so now we have to figure out the way to replace the executors and how does everything get to the kids. So part of the problem with estate planning is even when we have things, we don't keep them up to date. And so that can cause even further complications, because if this situation had happened and this woman died without a will, it actually would have been easier for us. But unfortunately, she had a will and just never, ever, ever, ever decided to do anything about it.
Yeah. And we've had situations also where like a page of the will was missing. Problematic. And we didn't know who the attorney was that drafted the will. So one big thing is know the attorney that did it. If you went through an attorney, have their name. They can never get rid of their files. We can usually try and track it down. Again, not fun. Sometimes we have to ask the court to have it released, but we can eventually get to the document that you created when we know who the attorney is. If we don't know and there's something missing, it can invalidate the entire thing, which is extremely problematic. So there's a lot of easy ways to avoid it. If you have to go through probate, it's not fun. We really try to avoid it. Brandon, do you have anything else to add on it?
No, that's really it about estates.
Do you want to?
Sorry, this is me. All right. So basic ideas, how do we walk this line? So it's really going to be two ways that you're always looking at this. How am I looking at this for me in my life and my family and my planning? But also you need to look at everybody that you're surrounded with, because who all might be expecting you to step into any of these roles? And how do I then do that? One of the really fundamental problems that we tend to run into is people don't know. It's not even a lack of having the document. It's I never knew in the first place that I was listed as power of attorney. I never knew that you wanted me to raise your children, whatever the situation. So a couple things that we always recommend, and what we'll send out to any of you on here that don't already have this, is we provide a very detailed packet of planning resources to literally anybody we meet. And we hand them out like candy. But part of this is going to be some tools that we can use. Number one, to have these conversations. I think we're the only law firm that gives out an actual script. So, what are some questions that we can either answer for the people that we are asking to do things for us, or use it in the reverse? If I'm expected to take care of mom and dad, what are some questions I should make sure that they are answering for me, so I have an expectation about what I'm doing and how I am doing it? So, number one, communication critical. You can't really over communicate on these issues. When it comes to the people that are stepping in, they need to know that they are stepping in. They need to know where things are, who to call, and how to do the job. Communication with heirs is really valuable too. So, a meeting I was at just an hour and a half ago, I have a pair of clients I've been working with for several years, and they have 3 adult children. And there's been some challenges that have come up because one of their kids is making very bad financial decisions. And so we're looking at how we might update the trust plan to maybe protect things a little bit better, or maybe take this child who was the one listed in all of these roles and maybe add some more people or add a professional partner who can help him make less bad decisions. But they asked me towards the end, should we tell them we're doing this? Should we ask them about this? And the answer is always yes, because we never want anybody to be surprised, number one, about what happens. But the bigger thing is, we're not going to be here. So we don't want to set the stage where we are inadvertently causing conflict for the people that are remaining, because that doesn't help anybody. So our office, just as an example, when we do planning, we offer what's called a family meeting, and we will bring in anybody you want to bring in. We'll bring in our clients, their children, their siblings, their agents, their whoever, and we go through an agenda and we teach people what is a plan, and then what is this plan. What do these roles do, and what are your expectations for doing them? We basically let clients decide what we say and don't say, but we try to facilitate a way to get everybody on the same page, so that 10 years down the line or 10 days down the line, people are going to know what they're doing and what they need to do in response. The second big piece is, regardless of whether people have a plan or not, make sure that they're organized. Organization falls into a lot of categories. It's not just things like bank accounts and tax returns and all of that. Think medical information, especially if you're taking care of a parent or somebody else. Who are the doctors? What prescriptions are we taking? What's the prescription schedule? Knowing that somebody's taking a pill is irrelevant if they have to take it at a certain time of day, with or without food, and so on. It gets to be really intricate. Beyond those, just the big ones, medical and financial, think through pieces like, well, what happens to our pets? Our pets have a plan. They also have needs just like we do. How can we better position them to being able to be taken care of by somebody else? And then having all of that in place so that that next person can reference back. And then we always tell people never make assumptions that people know what your wishes are when you can't tell them your wishes. The biggest and brightest example of that is if I'm gone, I can't tell you whether I wanted to be cremated after the fact. I can't tell you if I already own a burial plot that I spent $5,000 on, so don't buy another one. So one of the tools we give as well is really just this idea of last remains planning. And there's a person that we have kind of partnered with who's absolutely fantastic with her animaconity, and she does pre-planning. There's a lot of people that do it, but the idea is just simply make sure that there's a place that people can go, that they can find out what they need to do, where they need to go, who they need to call, and how they're actually going to be helping you in some way. Or again, if you are the helper, make sure that the person you're helping goes through these same tasks. Collaboration with professionals is always valuable. Accountants, financial professionals, medical providers, estate attorneys, all of these people kind of fill in their own little gaps. And so you want to make sure that everybody knows that everybody else exists, and then utilize them, lean on them for things. One of the biggest questions we get initially for probate estates is, how do I find out where the bank accounts were? How do I find out where the investments and insurance and everything is? Well, a great place to start is, let's look at last year's tax return. What are all the institutions that sent 1099s and K1s and all of those forms? We can just trace those back now to the place where the money is. And then the best advice, which is just impossible to follow, is you need to address probate as early as possible, probate needs as early as possible. And what I mean by that is, we get a lot of people who, we've got a dementia diagnosis. There's no powers of attorney in place. Dementia is one of the worst situations all around. It's one of the worst things to be diagnosed with. It's one of the worst things for families to deal with. But on our side of things, it's one of the hardest to respond to, because in order to be appointed, somebody either as like a guardian or a conservator, somebody either has to consent to that, or we have to get a letter from a doctor that says that this person is no longer capable of managing their own affairs. Dementia is a tricky one because people can present very well with lucidity, and it depends on the time of day that you're talking to them. It depends on whether they've eaten or not eaten, what medications they've taken. There's so many variables to it. As Alex had mentioned, some of these things take a lot of time. Some of these emergency appointments, yeah, we're waiting a week. There's a couple counties in Colorado, we wait months for responses, months for the court to even respond that they received something from us. So the earlier we can get on things and address and file and all of that, the better people are going to be able to be to step into these roles and actually help where they're needed. So that's the best practical advice that I can give. Kylie, you can jump to the next one. The last piece I just wanted to show you all, a couple resources I just wanted to make sure you had. Kelly, I did not know that you were going to be on this call. So shout out to Kelly. I'm going to actually have you to speak for just a brief moment in a second, but the Colorado Judicial Department, phenomenal resource. We have one of the best court websites in the country. There is a self-help page that covers everything from civil cases, criminal cases, guardian conservator estates. Highly recommend it for anybody to review. The Colorado Senior Law Handbook, for those of you unaware of it, there is a publication that comes out every single year. It is completely free to the general public. It is called the Senior Law Handbook. It is published by the Colorado Bar Association. It is hundreds of pages of resources and materials on everything from healthcare issues, legal issues, housing issues, age discrimination issues, all of these things. It's a really great thing. So I recommend For those of you who might need it personally or for family members, obviously go and download that. For those of you in a professional position that might provide resources to clients or partners, go and get that. It's free to everybody. It's wonderful. The last one is what I had put on here in advance. There is a fantastic new organization that is growing and growing called The Bequest. One of its founders, Kylee Baird, is here for anybody who doesn't know Kylee. Kylee, would you maybe just take a couple minutes and explain what you guys do?
Yeah, gladly. And thank you for listing it as a resource. But created Bequest really as a digital platform to connect family caregivers back to not only resources, but a local embedded community of service providers, really concentrating within the aging care space and end of life space. So to date, have about 100 professional service providers that have been vetted, are trusted, have come from another pro to pro referral source, and really look at specialists across legal, like Brandon and Alex, finance, really aging care, the biggest space, funeral, and then after loss. Kylee being one of those professionals. So, really, really looking to use tech and the digital platform as a way to really connect humans back to humans. There's so many do-it-yourself tools out there, but as we all know, there's just a knowledge transfer that needs to come from experts in the field doing this amazing work. And I myself have got to see, Brandon in action with my father, and just the passion for, what Brandon does, and Kylee is amazing to see, and just blessed to be a part of building Bequest and just this community of professionals.
Thank you. And thank you for being here. I didn't expect you to be
Yeah.
here. All right, and that was it for our side. If there's any questions, we're going to be here. I did put a little QR code. Anybody who didn't already have our information, it just brings up a digital business card, and then that's, of course, our information. But Kylee, I will let you take over for your side.
Wonderful. Thank you. That was really helpful. Before I jump in, I'll just take a moment to pause if there's any questions. I don't think I saw anything in the chat, but if anybody wants to pop in with a question or comment about the legal side, I'll just leave a moment for that. And if not, we'll open up for questions at the end as well.
I think the biggest question I have, and I don't know if it's a question as much as, how do we get education across to the consumers about, you don't want to lead with the most negative, but I think if people truly understood the cost range of not doing some of this, and what that means for a family that does have resources or doesn't have resources, I truly think more people would act. And I know we're all trying to figure out, how do we get people to be proactive?
Yeah, and cost is a hard one because it's also a very subjective term. I may not mind spending $2,000, $3,000, $4,000, $5,000 doing something, but I don't have the time at all. So, for me, the time consideration is a big one, but I don't know how much effort goes into this. I don't know how much time I'm going to have to spend doing it. So that's one of the challenges that I think just universally, we're never, not that we're never going to be able to kind of tackle, but it's hard to couch this in a way that is more universal for everybody in terms of the real life impact of dealing with these things. What I do tell everybody for our purposes is we sell peace of mind. We really do. Alex does all our probate work now, but I used to do very contentious probate litigation for many years. And I had judges screaming at me, and attorneys screaming at me, and banks screaming at me, and clients screaming at me, which was so much fun. And now I get to sit at a table across from somebody, and I get to help them get from point A to point B, which is nice. So, when we're talking through a lot of these topics, we try to couch it in terms of, we want this to be easier. We want there to be less effort, less time, less cost. We never really know what a particular person's situation is going to end up being, like on the back end, going through probate or anything, but we know that it's going to be worse than it is now. So, let's at least sit down and try to make things a little bit easier. And that's usually the best way that we can describe our level of services. And I think it kind of parlays a lot over as well into Kylie's side, because um, setting up a plan and getting out of probate and all of that, that's very technical. It's also pretty straightforward. One of the things that I always tell people is, like, the worst part of what anybody has to do is deal with all of the stuff, deal with all the personal possessions, go through the photographs, get access to the computer and the emails and all of those little pieces. That is truly one of the worst things that anybody has to do in their lives, cleaning up after somebody else. And so I think that's where a lot of these more collaborative efforts between different types of providers is really beneficial, because we all come together to make a big complete picture.
Yeah.
Great shout out there, Brandon. All right. So I'll jump in, and again, I think to Brandon's point, a lot of things that I do to support clients are those things that do tend to trickle down onto the family members or the personal representatives. Even when they have the other professional support, there are some things that those people inherently do just have to accomplish, figure out, do that detective work to find. And so I want to touch today on a couple of those categories that I support folks with. And the first one there is the immediate need side of things. So someone calls right away and they've just experienced a death, they've lost someone. Typically, the first thing that we're talking about is, who do I call for support? Where do I go? I don't know if they had a financial or a funeral plan. I don't know what their wishes were. So the first place we look, to Brandon's point, is hoping that if they met with an attorney, they filled out those final wishes in that document. I've worked with families who didn't have their documents, so that we were starting from scratch. I've worked with families who did have the documents and never filled out that component of the information. And then folks who did have those plans in place. So a culmination of the three. But when that plan doesn't exist, as we all know, if you've been through it, the emotional and the financial stress that can be on you as the family or the person who needs to make those decisions, that's a lot. We question, are we making the decision that was right? Are we making the decision that they would have wanted? Does this make financial sense? The finances that can come into this space can be difficult for people, because even if the estate can cover the costs, they may need to cover them up front if it wasn't already planned for. So one of the major things that we talk to with clients is funeral home preference. There's many great options. I know Brandon mentioned Hernando McConaughey. We work with a lot of places locally, depending on the needs and the desires of the family. Burial options in Colorado, there's 5 legal ways that someone can dispose of their body. There's flame cremation, water cremation, also known as alkaline hydrolysis. There's casket burial. There is natural burial, which is just the body is just wrapped in a shroud and placed in the ground. And then there's also body composting. So we're really in Colorado at the forefront of options as far as it goes for people. And all of those come with varying degrees of costs and details that need to be figured out. But again, if someone can decide beforehand what that is and what that means to them, it's really helpful for the family, because the benefit is there's more options. The downside is there's more for people to choose from at a time where choosing is already difficult. And then there's a ceremony and celebration wishes side of things. So, of course, sometimes if depending on the burial option that's chosen, there can be more time before a celebration or ceremony happens. Sometimes families choose to not do anything at all. And sometimes, depending on religious needs or the burial option that was chosen, there is a more immediate need for those things to happen quicker. So that's something that we can support folks with. And again, we connect with a lot of other professionals in that space. As Brandon mentioned, I think there's a real village in this space after a loss, of making sure that families are supported across the spectrum. We will send this presentation out to everyone on here tonight, but I did do a link through AgeWise, which is a nonprofit locally that just had a great kind of description of what those burial options were and some of those immediate things to consider when someone dies. Beneficiaries. So Brandon and Alex touched base on the estate plans, trusts, and some of the really great options that exist out there to make sure that assets are passed in the way that we want to. One of the other ways that can happen is through making sure that our beneficiaries are listed correctly. And some of the challenges that I see when an estate plan is incomplete or doesn't exist at all is that these can be outdated. They were never filled out. So think about a 401k account, and the only way that can pass to someone automatically is if the beneficiary is set up correctly. Secondarily, we want to make sure that that beneficiary is the person we meant it to be. I worked with a family where the father passed away and had been married for 20 years to his second wife, had been divorced for 15, and had never updated the beneficiaries to his children. And so his children, who are now adults, thought that they had access to these accounts. Unfortunately, the beneficiary was set up as the ex-spouse, and everything passed directly to her, even though they hadn't been married for 15 years. So beneficiaries, in many cases, it goes to that person who's listed. So again, just like it's important to make sure legal plans are updated, it's important to make sure financial assets and beneficiaries are updated as well. So just listed some of the accounts that should be reviewed there: life insurance policies, retirement plans, investment and brokerage accounts, and then checking and savings accounts as well. And working with an attorney can be really great to know who to list first or second if people do have a trust or don't. I know that attorneys can provide some great advice in terms of recommendations, in terms of where to list a trust versus a spouse versus whomever else. And then accounts that don't have beneficiaries do go to that estate and ultimately get distributed out according to state law, essentially. But so just one more thing that we help folks make sure that they are organized with before anything has happened is reviewing this section to make sure that they are organized and that their wishes are being taken out as they want them to be. Directories. So Brandon, I think on one of his last slides, mentioned that aside from the finances and the assets, there's some really important components in all of our lives that we don't always consider in just the legal side or every day. We all live such busy lives. We have so many things. We have so many accounts that we log into, and we know them. And so we feel confident in being able to access those as we need them. But a question I often ask folks is, what would the people in your life need to know if something were to happen to you that they don't know today? And often the answer to that question is everything. There's so much that we hold the information, that we hold the power to. So it's important that if that doesn't exist beforehand, that we're creating these directories of things like virtual storage items, devices, phones, laptops, not just where they are, but what's the code to get into them. Cloud services like Google Drive, Dropbox can hold a lot of great information. There's physical items like filing cabinets, offices, safe deposit boxes, physical safes in a home. And oftentimes, if we're working with a family that did not have any of these directories set up or these directions or wishes shared with people that mattered, we are doing what has been coined by another woman in my industry as empathetic detective work. We are trying to help figure out how to access these things. Sometimes the only way to access something like a phone without previous access is through a court order. And even then you're just getting maybe the iCloud data or something like that. So there's so much emphasis. We're talking in here about what happens if these things don't exist, but I know we all keep coming back to the pre-planning side, which we'll touch more on Thursday's seminar, but a lot that can be done beforehand. The other place that we look if these things aren't written or shared beforehand is, like Brandon said, working with other professionals to see, did the attorney or financial advisor or CPA have access or written down copies or records of accounts? Can we trace these back to financial accounts that maybe existed before? That might help us shed light on some of the things that that we need to address after death has happened. And then similarly, there's a lot of online searches that families can do, and I complete these for all of my clients that can at least help get that process started again. There's missing money, and we actually found a missing escrow payment that was re-owed to my dad after he had died using this link. So always good to check that one. And then there's unclaimed retirement benefits, IRS, lots of great assets there that people can search after a death or while you're alive, actually. Legacy information. So this is a little bit more of the emotional component of our lives, and something that there might be ethical wills is a term that people might know. And these are some considerations that folks may have wanted to have shared as something to pass down: lessons learned, recipes, family traditions. And I think something that's great here is, even if someone hasn't necessarily written this down or created, again, that directory of these things, that family members can take the time, or personal representatives can take the time after death to honor the loved ones by creating things in this space. So maybe this is a story that someone told. Maybe this is, again, grandma's famous lasagna recipe that only one other cousin knows. Writing those things down to share with the rest of the family can mean a lot after a death, especially when there's grief happening. So a lot of different spaces in this world, but when we work with folks on the pre-planning side, we try to make sure that anything that's really important to the family is written down, is somehow documented, so family members know what those things were. We have a family that we're working with currently, and we've been working with them for quite a long time now. And the matriarch of the family is an amazing cook. She is just, everything's by heart. She's the pinch of this here, pinch of that there. But one of the things that she mentioned when we were talking about this section was, if something happens to me, everyone's gonna be devastated because I know the recipes. I hold the recipes that we make during holidays and for birthdays, and no one else knows them. And so that's one of the projects that we've been working on with her, is creating a recipe book that she's going to share with all the family members this Christmas. So again, some of these things are maybe not as important as it comes to the financial or the legal outcomes, but can mean just as much to folks on the sentimental side. Our digital presence. So again, we talk about our legal assets, or the things we need to do legally, the things that we need to take care of financially. Obviously, those are incredibly important. Our lives are so much more lived in the digital space these days. And we don't think about what those assets in those accounts might look like when it comes to what happens to these when we're gone. And so if someone has passed and we don't have access to these things, or we don't know where these exist, it can make it more difficult to say, how do I close these accounts down? How do I memorialize the account, which is an option for a lot of social media accounts. And so something that Colorado has, and actually many states throughout the US, and I may bring Brandon and Alex in to touch on this a little further, but is the revised Uniform Fiduciary Access to Digital Assets Act. And what that allows is, once there is a legally authorized person, a personal representative or a trustee, it does allow access to manage those digital assets, those electronic communications. What that looks like, if you aren't that person and you have maybe the password and username, what I say is there's no password police. However, there are some restrictions and some outcomes that can happen if someone does try to access a digital account without proper authorization. Brandon and Alex, if you have anything to add to that before I move on, I'd love your input.
I'll give a couple quick notes, and then Alex, if you have anything additional. One is, there is a reference that Kylie made a moment ago about like Apple, just as an example. So private companies are allowed to have their own policies and regulations about access to information. Apple is the most notorious. They do require not only a court order in order to be able to access like an iCloud account, but the court order has to be extremely specific and meticulous to their requirements. And without it, they'll just flat out reject any attempts to get in. Apple has actually implemented a legacy contact program, which I tell everybody about now, because it allows people to access iCloud. You set it up through your phone or your tablet or whatever you want. You can have as many legacies as you want, but it allows you to basically bypass this court requirement. So the point is, for people with the individual programs and operating systems and all of that they use, I do always recommend people research what potential legacy options would be available, so you don't have to go through this Colorado revised act and jump through a bunch of hoops with the court system. The other thing
Yeah.
is, there are potential civil and criminal penalties for using other people's logins. So like a very problematic example that I hear way too often is, oh, my husband just died, or my parent just died. Well, I had their login to their bank, so I just went on and I transferred all the money out of their account to another place, where I had access. Pretty big felony. So we want to try mitigating committing crimes after somebody becomes incapacitated or died. So the fact that somebody has access doesn't mean anything, because unless you are that person, certain decisions that you make can have severe penalties. So I always just caution people, if there's an accident or if there's a death, just don't do anything. Just stop exactly where you are until you talk to somebody that can actually inform you from a legal perspective on what you can and can't do.
Brandon,
Yeah.
what if you are on the bank account with your parents?
Different situations. So like if you're on as a joint owner, or you're on in certain capacities, so like let's say parent is still alive, you are the power of attorney, you can make any transactions. But a common example, parent has died, but you were the power of attorney. Power of attorney ends the moment we die. So like any transactions that we try to do after the date of death, after the moment of death, are illegal. But the bank doesn't know that yet. So I'm just going to move all the money out and put it in my own account. And so, it depends on the very specific technical pieces of who's on accounts and in what capacity they're on accounts. But general rule of thumb is just tell people to stop. just don't do anything. Talk to somebody, and then they can tell you what you can and can't do.
Yeah. Great question, Juliana. And thank you, Brandon, for jumping in there. There's, again, when I work with families in this space, of course, there's always big questions of how do I do this? How do I do that? And like he said, one of the first things that I recommend is let's get some guidance from someone in the legal field, because there's so many components to think about and every estate is so different. So like he said, while this act does allow these legally authorized folks to manage some of these assets, there's still so many that are governed by their own terms and services. And an example I'll give, there was a family where the father had passed away. They were simply trying to delete the Facebook account of the father, but they were guessing the password. They didn't know it. They knew the username, but not the password. Tried several times to log in after he had died. And then at a certain point realized there actually is a process that Facebook has where you can request, send a death certificate and have this done. But because they had seen that they had tried to log in after the date of death so many times, they flagged it underneath their terms of service as fraudulent activity, and therefore they would not close the account. And so now the account is still open in perpetuity. There's some options to get it memorialized at that point, but again, the terms of service for each of these unique institutions are sensitive. So that's one of the ways that we help people is A, let's make sure we get that legal guidance. And then B, once we have that, is working through each of these institutions, various, because they're all different, needs of memorializing or closing accounts, and making sure that that's done properly. So something I wanted to end on for my section for all of us here today is what are digital legacies? And Brandon kind of did a nice entryway into this, but there are a lot of options that we can do and take right now while we're working with clients who have the capacity to make these things, to create legacy accounts, to create emergency or legacy users rather, and to create these emergency contacts that will allow these appointed people to access the information that we want them to, or that they will need when we're gone or when we're incapacitated. And so just one of those that I wanted to share today is for any of you today who are Apple or iPhone users, there's quick instructions on how to add a legacy contact and also how to add your emergency contacts. And again, we'll share this PowerPoint out so you can see these things. But as Brandon mentioned, with legacy contacts, it truly, this is a soapbox that I stand on with every person I meet and client that I work with. This is going to take us less than 5 minutes. And it is so simple to do. You just go through your settings, you add a legacy contact or multiple legacy contacts. You can add phone numbers, emails, however way you want to contact them. And that person will be able to, using a specific code that's sent to them, access your iCloud data when you are no longer able to. Similarly, I think emergency contacts, while a lot of folks think that that's just something that 911 would use if you were in a car accident, this can be used for lost devices. I actually found a woman's phone in a Target parking lot and was able to use her emergency contacts to return it to her last year. You can also put things in the notes here about maybe medical wishes or medical components that folks should know should you be in an accident. So both of these things are great. And as Brandon mentioned, you can also do this with Google, and Google manages most Android users. So if they don't have an iPhone, it should be done through Google. And then Meta, which is Facebook, Instagram, WhatsApp, they have a process for this as well. Many other institutions do as well, but those are 3 of the big social digital spaces that we see. And that's just one area that, again, if there has been a death, I always encourage folks and I help them search to see did this exist? Are there any codes anywhere? And if not, then we go through the other processes to make sure that these accounts are closed appropriately. So we will move on. That is the end of tonight's presentation, but any further questions that we can answer, again, this is all of our contact information, our websites, phone numbers, if there's anything we can answer for you all. But we really, really appreciate you all being on here tonight. And again, welcome any questions, comments, or dialogue that you may have.
Kylie, I don't have a question, but I do have one quick note and something we can add into your presentation moving forward. On the resources page that Kylie had shared about like locating assets and different things, one piece that most people aren't aware of, there is an organization called the National Association of Insurance Commissioners. They actually have a website where you can look for insurance, life insurance policies that a deceased person may have had. It's incredibly helpful because a lot of people who pass away, let's say if I'm 95 years old, I may have taken out a policy in the 70s. And so my family trying to trace and locate that information, it's incredibly difficult. So there is a website you can go to. It's just the National Association's website. There's you can literally just Google, search, life insurance policies, and you can plug in basic information and it'll tell you if there's any policies, at least in their records. So
Yeah, we'll add that in before we send it out to everybody. Thanks, Brandon.
I have a question. Are there any differences like between a living will, 5 wishes, and like a most form? Like what's legal wise, or are they 3 different things?
They are 3 different things for the most part. So a most form we can actually not complete as attorneys. It has to be done through a doctor, and that is like do not resuscitate. Some of those kind of more medical technical things, and you have to go over it with a doctor, and a lot of doctors won't even talk to people about it until they're very late stage of their lives, and it's on a bright green form, so people who say they have it and it does not look like this lime green thing, they don't have it. And then a living will and 5 wishes. A living will only deals with if we've been placed on life support, it's how we get off of life support. It really only deals with that situation. Currently in Colorado, that means 2 doctors have to determine you have a terminal or incurable illness or are in a permanent vegetative state. And then you have to remain on life support for at least 2 days. Cannot shorten it. That is just the way it is if you've been placed on life support. Brandon, you have more experience with 5 wishes if you want to jump in on that one.
yeah, so just for everyone's little edification here, the 5 wishes form was actually created by the Catholic Church. It was done in response to the kind of legal structuring that we had available for estate planning. Orthodox Catholic faith has a number of very, very strict rules about who can make decisions and how decisions are made when we're at the end of our lives. And so in response to that, several decades ago, I think it was the 60s or 70s, the Catholic Church created the 5 wishes form as kind of an alternative for their congregation. The 5 wishes, I tell everybody, if you have nothing, have the 5 wishes, because it's going to cover some really key topics about who makes decisions for me and some specific focuses of what those decisions are. The biggest red flag that I can give people is under our legal system, the 5 wishes is recognized as a legal directive. So if we fill out and sign that document after we have filled out and signed any existing estate plan documents, the 5 wishes will revoke and replace those prior instruments that we created. So if I had a medical power of attorney and I subsequently created 5 wishes, well, that power of attorney is no longer effective.
Isn't that amazing that people don't know this? I just learned this
It's
from
because it
another
doesn't
attorney.
tell them. There's no warnings about it, which is shocking.
It is
And it
shocking.
is
How did
so
they
much.
get that so mainstream into every hospital?
Yes,
know.
every hospital gives them out. You're right.
I know.
Yeah.
So the problem is if you read a medical power of attorney, usually right at the very beginning or right at the very end, there's a disclosure it says by signing this document, I am, revoking any prior powers of attorney. There's a legal disclaimer in any power of attorney. There's not in the 5 wishes. So we just need to be really cautious about that. So I tell everybody, if you've got a 5 wishes and that's all that you have, it'll help your family. It will make things easier. Once you have an estate plan in place, just don't use a 5 wishes. Really for any purpose. We can use them to like help people build on their estate planning if they have particular things that they've written in there that they now want to say in their regular documents. That's fine. I've also had people who they wanted to fill out the 5 wishes because of the way that it's laid out and the different things that you get to say.
Yeah.
That's fine. Fill it out. Don't sign it.
That's right.
And then you have these guidelines now that they can use in addition to the power of attorney you gave them. So 5 wishes is kind of a dangerous one because people don't know the potential ramifications of it, which is really frustrating.
Yes.
It's so much less
I think
comprehensive.
Yeah, and
every
it's so much less
palliative
comprehensive.
organization needs
Thank you.
counseling because they're out there just handing them out
Like
in the ICU. Yeah.
Brandon, you mentioned the resource, packet of planning resource. Did you
Yes.
say that you will send that?
Yeah.
us?
So what I will do, Kylie, since you're going to send out the PowerPoint, I'll just give you the packet that you can give out. You already have it, I'm sure, but I'll get that over to you so you can send it along with everything.
That'll be really helpful when we're talking to folks.
Yeah.
Thanks, Brandon.
And
It's a fantastic resource, just a plug for it. It's best in class.
well, I'll tell you, we have these resources for estate planning. We have a very, very in-depth resource for what happens when somebody dies. Kylie is in that one, actually. And then we have a bunch of things just on a bunch of different topics. So my offer, I will always have to every single person that I meet is if you need a resource on something or if you have a question on something, just ask it. If we have something, we'll provide it. If we don't have something, we'll create it.
Wonderful.
Any other questions or comments? Well, we thank you all for joining us tonight, and
Yes, thank you.
thank you for spending this precious time with us. We will respond to everyone in this email with the recording of this video, the resources that Brandon and I have both mentioned, as well as some of the extra PDF support tools as well. So thank you all so much and hope you have a wonderful evening.
Thank you so
Thank
much.
you
Very
so much.
You guys.
appreciate it.
Thanks,
Thank you.
everyone.
Thank you.
Awesome.
Thanks. Bye.